it's the same thing. It doesn't matter whether you had a will or not. So let's start with what happens when someone passes on. The first scenario, there's no planning. Unfortunately, this is the most common thing that happens. There's no estate plan in place. They didn't do anything. So everything ends up in probate. And well, who are the beneficiaries? The state decides who your beneficiaries are. Do you really want your estate plan done by your state government? Most people say no. So when you end up with no plan, it means assets are in probate. The state has determined who your beneficiaries are. Everything is then subject to a court process with inventories, and they want copies of canceled checks and account balances as of the date of death, and every penny needs to be accounted for. And we're going to get into the 4 big downsides of probate, but it can be very costly, time-consuming, and very, very frustrating. And at the same time, the person never actually got to pick who their beneficiaries are. It's just in probate, and then it goes to the beneficiaries that the state has outlined in its intestacy laws. All right, what about a last will and testament? Okay, great. There's a last will and testament. They did an estate plan. It avoids all that stuff, right? No. Unfortunately, everything that I just described about probate, how there are inventories that have to be done, and this is a good place to talk about that actual process. Somebody passes on, somebody has to come forward and say, yes, I want to be the administrator, or if they have a will, executor. Basically, the general term is personal representative. Someone wants to be that personal representative. So here's, okay, fill out this inventory, sign this oath, get this information, put this together, send it into the court, and then the court has to approve the person. Well, what if they weren't first in line according to the law? Without a will, that's it. Okay, your closest relative gets to apply. They get a preference unless there's something wrong. And now it's actually could be debated and contested who should be the person handling the estate.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
All right, so all those that inventory has to be your, quote, best guess. Once that happens, you get the court papers that approve you to go in, start collecting assets, and start gathering things up. And then you have to do an inventory. That's usually second phase. When you were if you were doing a kind of initial inventory or, quote, application listing assets, it has to be your best guess. Well, why just your best guess? Well, because no bank or other financial institution is going to give you information until you actually are appointed, and that's part of that first process. But now that we're at that second level where someone is approved to handle the estate, now they want exact numbers, down to the penny, of value on the date of death. And there needs to be written proof and documentation about what that value is as of the date of death. So you've got to gather up that paperwork, gather up those statements, start collecting the assets, potentially liquidating them or at least retitling them into the estate. An estate account has to be set up. There are all of these different rules and procedures and things that have to happen at that phase. And that second thing, the inventory, has to be, here is exactly what the picture is as of the date of death. All right? Then we start paying bills, handling final expenses, taxes, whatnot. And then there's the final inventory, or if it's going to last more than a year, and often it does, an annual accounting, saying here's where the assets are, here's what went out to the beneficiaries, here's the debts that were paid, and here's all of the documentation that it happened. The final inventory, everything has to be down to zero for the estate because everything has been sent out to the beneficiaries, and there's a bunch of paperwork that the beneficiaries have to also sign to make sure everything's good before the personal representative is released from their duties and the estate is closed. So quite a bit of a process. Well, what happens if you have a last will and testament? Well, there are only a few things that are now different. You can nominate the person who would be your executor, so you're kind of choosing that person. And you're choosing the beneficiaries. Great. But does it avoid probate? No, it doesn't. All of those procedures, and I just gave you the kind of top level view, there are lots of different permutations, and it can vary a little bit from state to state, but you got to choose who your beneficiaries are, and you got to nominate the person who would be handling the estate. Other than that, all of those procedures, at least in North Carolina, it's the same thing. It doesn't matter whether you had a will or not. So if anyone's ever told you, oh, I have a last will and testament, my estate avoids probate, 100% wrong.